Another big category of threats is from stormwater, which is just essentially rainfall that is hitting all the increased paved surfaces that come with development and then running into the marshes and the creeks. Stormwater is a huge issue. A lot of the county governments and the local planning boards down here are trying to deal with stormwater. We are trying to help them in that process. It is a really, really complicated bed of regulation. There's local regulation and there's state regulation and there's federal regulation, and nobody's very clear who does what or what they're allowed to do. But it's a huge issue, and it's something that we feel like as we continue to grow and we continue to create new paved surfaces, new housing, we really have to address how we're managing that stormwater. So we have been, after this report, working to really sort of firm up the conservation community down here. Again, comparing Georgia to, we work also, as I mentioned, in South Carolina and North Carolina, and they have a more organized conservation community in those states, and they in some ways have been more effective there for that reason. And so one of the recommendations that we made is that we felt like the Georgia coast needed more attention and needed a more collaborative and comprehensive group working down here. And we have been working with lots of local organizations. I think we are now in a coalition with about 12 other entities, many of the Riverkeeper organizations, the Georgia Conservancy, who you all may have heard of, other local groups. We now have formed a coalition called Save Our Coast, and we are in a planning process with that coalition where we are working on identifying a strategic plan for this region, further, fleshing out what really needs to be done, what the biggest issues are, and a timeline for prioritizing how we work on those issues. We at SELC are also continuing to look, just from our own organization's perspective, at the Georgia coast and what we think are the big hot button issues down here. I'm just going to touch on a few of those very briefly, and then I'll open it up for questions. One of the big ones that we think really deserves attention is this issue of protecting the salt marshes and estuaries as more and more structures get placed in the marsh. And Georgia's really unique, actually, in that there is a statute called the Coastal Marshlands Protection Act. It's very forward-thinking. It requires a permit before any structure is placed in the marsh or anyone is allowed to alter the marsh. So that's great. We're very fortunate in the state to have that. The issue with the statute is that the government agencies have taken a very narrow view of what it actually regulates. So they say that the statute, in their opinion, only regulates the actual physical structure you place in the marsh and not any of the impacts that are associated with that structure. So, for example, if you were to build on a marsh hammock, and you had to build a bridge to get to that marsh hammock, they would say that the only impacts are the impacts from that actual bridge in the marsh and not the greater development that you do. And so we've actually viewed that as problematic. We think if the point of the statute is to look at and to protect the marsh, which is what the purpose of the statute is listed as, you really have to look at all the impacts. We brought a case on that. We actually have that case now before the Georgia Supreme Court. They heard it last week, and there's a developer on the other side of the case. They believe the statute should be interpreted very narrowly and only regulate a small amount, just that small part that you place in the marsh. We're waiting for a decision on that, so that's going to be interesting. It should be out in December, and we'll see where we go with that. That's really something that we're going to continue to work on down here, though, is how we deal with impacts to the marsh if that statute turns out not being a tool that we can rely on. Another big issue that is really, it's bad from the conservation community's perspective. I think it's bad for developers and it's bad for homeowners as well, is this issue of whether there has to be a buffer on the marsh. That's something that we see. It's just so interesting. If you travel from Savannah and then you travel from here and go down to Glenn County, there's a huge disparity in whether state regulators require developers or homeowners to set any development on their property back at all from a marsh. So in some counties they require a 25-foot setback. In other counties they don't require anything, and you can build right up to the edge of the marsh. There's a Georgia statute that we feel requires a buffer on all state waters, and that and we believe the marsh is a state water, and there should be a buffer. At one point in time, the Georgia Environmental Protection Division enforced it that way. They've since sort of stepped back from that, and now are not sure that they can enforce it, and so there's just this big hole of unpredictable regulation where no one knows quite what is required. So we've been working with local governments on that issue. A lot of this is enforced through local ordinance. We've been working with Chatham County MPC and the Chatham County engineers, talking to them, talking to the Glenn County folks, and trying to figure out if there's some way we can solve this kind of quagmire where nobody knows what the law is, so that at least people know what the law is. Even if we don't establish a buffer, we all know what the law requires. And then another issue that we continue to work on is just guarding against the future loss of wetlands. We feel, as I said, that this is a big problem as development keeps coming. And the Clean Water Act prohibits the dredging and filling of wetlands without a permit. But what we see happening a lot down here is there are some exempted activities from the Clean Water Act, and those tend to be silviculture and farming and things like that. And there are a lot of old timberlands in Georgia that are not actively in forestry operations right now and are being converted into development, which everyone has a right to do, to sell those, but they're placing roads through wetlands for purposes of development and calling that part of a silviculture operation, and escaping all of the permitting requirements. And so that's an issue that we've really been watching, and we just won a case on that, actually, more or less in federal court, almost wrapped up on that. So with that, I think I'll conclude. I'd be happy to answer any questions that anyone has.